So last class we looked at the uh, 6 different steps in filing the patent, or if you are an inventor, how can you procure the patent or get the patent rights of your invention. We looked at 6 different steps, that is application for grant of patent, then provisional or complete specification, then third statement of undertaking, 4 declaration by inventor, 5 request for publication, and 6 request for examination of application. So this is what we have discussed in the last class. So here today we'll be studying pre-grant opposition and post-grant opposition. That means if any of them in the society or in the public wants to make a statement that is oppose, right? Basically oppose your invention, they can do it in 2 levels. One is pre-grant. So a representation for pre-grant opposition can be filed by any person. That means there is no partiality between it's only a company who has to file opposition against your invention or only an individual person. There's no that partiality. Any person, whether an institution or a company or an individual, can always file an opposition letter uh, on your invention as per laid under the section of 11A of the Act within 6 months from the date of publication. So we just looked at the last step where the request for publication is mentioned, correct? So now once your invention has been published, then within 6 months time period of that date, anybody who wants to oppose may oppose your invention. That's called as pre-grant opposition. Next is post-grant opposition. Any interested person can file post-grant opposition within 12 months. That means one single year from the date of publication of the grant of the patent in the official journal of the patent office. So first, here we have seen that it's just a publication of application. Now here we can see your invention, your idea or your work has been published where? In the official journal of the patent office. Okay, so that means the entire world will know that you are an inventor and what is your invention. So in this case, the patent act gives you almost 1 year time. 12 months is 1 year, 1 year time, that if any of them wants to oppose the invention or oppose the patent. Is that clear? That's called as post grant opposition. Now let's look at the grounds of opposition. Number 1 condition is patent wrongfully obtained. That means if you have copied somebody's else patent, or you have copied somebody's else process of inventing, right, without giving credit to the process, the person who's invented that particular process, that means you have wrongfully obtained the patent. So that can be one of the important grounds for anyone to oppose your invention. Number 2, prior publication. So that is why we mentioned in the very first step, correct? You remember the steps in granting patent. The very step was the history of this invention must be provided in his application. That means if anybody else has filed an application for the same invention that today you have invented, then based on that, persons can file an opposition letter for your invention. Based on what? That's stating that you are not the first person to invent this. There were people in the past or in the history who invented the same invention. Is that clear? That is called as prior publication. Step 3 or ground 3, the invention was publicly known or used in India. That means nobody just got it patented, but certain inventions were publicly used, right? It was in usage in across the borders of India. Then also your invention can be opposed. Number 4, the invention is obvious and does not involve any incentive step. Now you remember what is the criteria for a patent to be patented is what for an invention to be patented is it must be new. Yes or no? It must have novelty. You remember that step? It must be new. It must be also the third step was non-obvious. That means what? You are the only person who thinks that way about that invention, the product, the service, or the commodity, the design, etc. Nobody else would have thought that way, right? It should not be so obvious that every other person knows how a particular machine works or a particular design looks. No, it must be not obvious. So if your invention that you have published is obvious and does not involve any incentive step, that means incentive means what? Something new that only you would know, that only your invention can showcase. If that is not there, then again that will be another ground for opposition. Number 5, insufficient disclosure of the invention. That means you are not uh, disclosed the complete source of invention, right? How did the idea begin? Like we told in the second step of granting invention, remember? Complete or provisional specification. There in detail you are mentioning how did the idea cross your mind, right? What are the raw materials you have used? How did you come across this invention? Everything in detail and specific you need to mention. In case you have not mentioned it 100% completely, you have just partially mentioned it, that means that also that immaterial or partial information disclosed, that means it is basically insufficient. There is no complete disclosure of the invention. When, how, at what place was it invented, at what time, or what were the raw materials used, how did the idea cross your mind, is it industrial usage, etc. All these things are incompletely mentioned. Therefore, insufficient disclosure of the invention will also become a ground of opposition. Is that clear? These are the first 5 grounds of opposition. Next, seventh one, that the complete specification does not disclose or wrongly mentions the source and geographical origin of biological material used for the invention. Okay, that the complete specification does not disclose. Okay, so whatever in the step 2 that you're in the application, you have specified or disclosed about the invention, either that specification does not disclose the actual invention or it wrongly mentions the source and the geographical origin of the biological material used for the invention. Basically, yes, you have specified everything, but that does not result in this invention. Okay, whatever you are specified in the application, that specification does not result in the invention you're claiming to be inventing. Is that clear? Either it is wrongly disclosed or wrongly mentioned about what, as I told, where did you get this idea, or what is the source of raw materials that you have used. Okay, the geographical origin, which country. Now if I say so and so bulb was invented by Edison, or telephone was introduced by or invented by Graham Bell, so I'm giving the credit to the person, to the invention, and to his country. Okay, let's say Graham Bell belongs to USA. Now the credit goes to that geographical location as well, right? So and so country has so many patents. Now if you go to this patents or even website, and you will have a list of inventions or list of people or organizations who have invented or got their patents registered under the Patents Act. What does that display? Who has invented it, what have they invented, and to which country do they belong. Though they also show you a list. An Indian country has around 150 patents. USA has around 200 patents. So the credit also goes to where? The geographical location as well. Okay, so that gives a credit to the, that's a pride moment for a country, correct? So here in this grounds of opposition, whatever you have mentioned in the application is wrongly disclosed, or it does not mention the right source of origin. Is that clear? So that can be one of the primary grounds of opposition. Number 8, that the invention was anticipated having regard to the knowledge, oral or otherwise, available within any local community in India or elsewhere. So, whatever that you have invented, people already are using it, or people already have the knowledge of it. As I told, when it is non obvious, you are the only one who should have had the knowledge about it, or let's say the idea perspective about that invention. But in somewhere in any local community in India, if people have orally that knowledge, right, how that some kind of invention works, if it is available in India or elsewhere in the world, then that can also become one of the grounds for opposition. Is that clear? So these are the 8 different grounds of opposition. We studied about the pre-grant opposition, post-grant opposition, and grounds of opposition. That means wrongfully obtained, prior publication. Third, the invention was publicly known or used in India. Number 4, the invention is obvious and does not involve any inventive step. Number 5, insufficient disclosure of the event. Number 7, that the complete specification does not disclose the original origin of the invention. Number 8, that it was having to be anticipated that invention having a regard to knowledge, oral or otherwise, was available within the local community of our country or elsewhere in the world. Is that clear? So this completes your complete topic about the Patents Act.